Hey guys,
Hey Nina, what's going on?
girl, just out here doing trademarks and stuff. It's that day of the week, y'all. It's trademark that Thursday. I've been having fun, y'all. I'm playing with TikToks and trademarks, and people been liking these TikToks about trademarks, so I might stay with it. But y'all go find me on TikTok. Y'all know. I mean, I'm not gonna put up my little thing. If you follow me on Instagram, you probably see what my TikTok name is. But if you don't, I mean, just follow me. Follow me. I'm fun. But yeah, TikTok is not my new favorite thing for trademarks. Yeah.
It's a vibe. It's a vibe. So check this out. So, we're in the middle of a pandemic. Kind of takes the time. Everybody kind of does some throwbacks. And I found myself listening to J.Lo the other day. And for some reason, I decided to Google her, right?
I'm still Jenny from the block. Okay, let me stop.
Right. Right, right. So I noticed something that came up with her and like Glow Industries,
Oh, wow.
her getting sued back in the early 2000s.
Oh,
Um,
dang it, J.Lo. Getting sued for trademarks. Everybody getting sued for trademarks, apparently. What's going on
right.
with J.Lo? What do they say?
Well, apparently there was some issue between J.Lo and Glow Industries um, over the word glow, right? Right. What it was is J.Lo has, or she was, had a plan to come up with like this, this like skincare, like body care, like perfumes and such like that, to boost her brand. But there was another company that was doing something similar. And
Mm.
there is also like a dermatologist who had something with skincare that had the word glow on it as well. Like I kind of looked at the news article, but I'm sure you would probably know more than I would. So
Yeah.
what do you think?
What's the big question that they have, the first one that was really like pressing for this one for you?
I feel like the biggest issue was the right to use the word glow.
Ooh, man. All right, so let's break into this from the trademark perspective. So yeah, put your trademark hat on, and if you don't have one, it's cool. I got one. Shane's got hers on. So basically, I want you guys to think about words that you see common in the beauty industry. Do y'all normally see the word glow in the beauty industry? Is that what you see, Shayna? You seeing the word glow? All right. So y'all remember way back when, okay, well, long trademark Thursdays ago, okay, we had the little whoosh effect, like in TikTok, I would do the little cloudy thing. But again, like way back in trademark, that Thursday's land, I told you about weak and strong trademarks. And this is where you see it play out. So the word glow, if it's used in the beauty industry, well known and well used in the beauty industry, it is considered a generic mark. At best, it could be descriptive, but it's definitely not at the higher level, which is that suggestive level that we try to get our clients to. The reason being is because as you are doing a trademark, you're trying to find things that are not in the industry. When I was just looking over, right, just looked at Glow Industries versus J.Lo, wanted to see what was going on. I looked at the state law case and they handed Glow Industries their butt. Do you know why? Because of the word glow. And the reason why it's not going to be a trademark infringement issue, more than likely, is because Glow is going to have a hard time proving that glow, the word glow, is something that can only be exclusively used because there are products like the Glow Male Pale. There are products like Glow Aromatherapy Oils. There are Glow Naughty Pillow Mist. I kid you not. There are Glow Soaps. There are Glow Bath Truffles. There are Glow Tub Truffles. There are Glow Bath and Body methods, anything with the word glow. Do you know within the state law case, just the state law case alone, they mentioned how many times the word glow was used in the industry. They use the word ultra glow, there's amber glow, there's beauty glow, all of that. Glow is generic, and the reason why you get a trademark attorney to kind of help you navigate that is this: if you put out a generic trademark, right, or you're trying to protect or say that you're having it infringed, because again, You don't have to have a trademark application to allege that there's been trademark infringement. You have to have first use. You have to establish that you had first use. And when you establish it, you have to show the geographic reach of your use. Now, it helps when you have the application because you don't have to establish so many things, so many factors. But for this particular case, with the use of the word glow, J.Lo wasn't actually in the wrong here, which is what a lot of people did think, right? They're like, oh, it's just a celebrity bullying some little small company. That's not what happened here. The word glow is not exclusive. And that's why a lot of people, when they go to trademark it, and sometimes, people press go on their own. And Shayna, you and I have talked about that before. People just go ahead and press grow, and they're ready to go ahead and trademark their brand, and they don't want to ask a trademark attorney because they don't want to pay one. Well, this is what happens when you don't do that, because the word glow isn't exclusive. So if you name your company Glow Incorporated and you think you're going to be able to prevent anybody from using the word glow by a trademark infringement claim, you're going to get a really tough handing to them, like they did with their case, because they cited, I believe, 9 different companies in the state law case against them. And then they also cited about 7 more companies after that use the word glow, that have products. And if I can find, and if the state law case can find about 16 different products with the word glow in it, then it's not exclusive and it's not really something that you want to trademark. Because yes, you can trademark anything if you want to. Is it smart to trademark anything is the question. And that's why a lot of people seek out trademark attorneys. So Glow Industries messed up when they tried to enforce the word glow against J.Lo, because first of all, you don't even own that trademark. If you owned it, it would be an issue, but you don't own it. So that was their first mess up there, Shayna. Any other questions that was really kind of bothering you that you really want to know more about?
Yeah. Okay. So I understand that like they didn't take, I guess they didn't take the opportunity to grab the trademark before J.Lo could. But I feel like I guess my main question is like, why couldn't they both exist?
Coexistence. Ooh, that's a
Right.
fun.
Like,
That's a
you know what I
fun
mean?
one.
Like,
Yeah, coexistence. That's possible. See, you've been doing your homework on trademark. I like when you do your trademark that Thursday's homework. I appreciate it. But coexistence is what you're asking about. And yes,
yeah.
good for a lot of people if everybody operates in good faith. As you read in the case law, and if you go look into Glow Industries Incorporated versus Lopez, it was a lot of drama up in there, okay? But the reason why coexistence or coexistence agreement wasn't put in place is because coexistence really doesn't do anything but dilute the brand if the two parties that operate in agreement, right, at first, good faith, they end up going into bad faith. And that's what Glow Incorporated or Glow Industries Incorporated and J.Lo would have had happen. Because if you do a comprehensive search, then you know what not to go ahead and trademark or what not to try to get a coexistence agreement in, because you're not going to build your brand around something that's already established or something that everybody has claim over. You want to trademark in something that no one has claimed. Who claimed Google before Google? Who claimed Xerox before Xerox? The different parts of the world, that's usually this coexistence issue. So the fact that J.Lo wanted to create it for her makeup and her perfume line, that's on J.Lo. But the fact that you had a glow kit and you were selling kits in the industry about, trying to make your face all clean, that doesn't mean that you want to create a coexistence agreement. Coexistence means that you can both operate doing your own thing and that your products are distinct, but it's splitting the baby. So I operate over here in Illinois and we good, but you operate over there in California and we good. I don't want to restrict myself to Illinois. I don't want to not be able to market to people over in California, because that's what those coexistence agreements are. One good example that I like to refer to is Apple Corps versus Apple Corps, the record label that was created by the Beatles. They were allowed to coexist in the same field. I kid you not, with the same name, Apple Corps and Apple Corps. Both of them own that trademark. However, one was for electronic devices and one was for record labels. unless you're going to have something that distinct like that, where there's no overlap in the industry, coexistence isn't really to your benefit if you're both in the beauty industry. That's where the intersection was going to happen here, because even though they didn't sell perfume, beauty industry sells perfume. That's something that's promoted in the beauty industry. And what if I wanted to sell perfume? What if I wanted to make my own perfume? And I would not be able to do it if I had a coexistence agreement. So a lot of people don't do it. And then also, the trademark office will invalidate something that's against public interest. So coexistence agreements, if they are against the public interest or they create some type of antitrust violation, then you're going to have a difficult time enforcing those over time. So the biggest thing is to get a good comprehensive search done day one, and to trademark in an area in which you don't have to coexist, because no one has your trademark. No one has made up words. No one has more but stronger trademarks. And that's something that a lot of people prefer, because coexistence is not guaranteed. It's not guaranteed that that other company is going to want to coexist with you in order to dilute their brand and for them to merge away from you. But it can happen, but I wouldn't have recommended it in this case.
Okay,
What
so
else?
that makes sense. All right. Okay, that makes sense. I get that.
Okay.
So as you're speaking, I also think, I guess my other question would be like, what's the difference between like a company that's been marketing and selling under a name and they've built somewhat of a reputation and they're fairly well known versus like actually owning the rights to use that name? Do they have any type of, I guess for lack of better wording, dog in the fight? Does it come down to popularity?
Yes, they have a dog in the fight. This is that first use versus first, like first application or first to file. Common dispute. People are like, I used it first. Yeah, but you got to prove first use. And sometimes people prove first use by just showing the application that put everybody on national notice. But your first use, you don't have those same statutory like allowances as if you had filed it. So a lot of people, and I tell people to kind of refer to my Lady A versus Lady Antebellum. I don't know if you guys have been keeping up with it, but that thing, if you don't create a paper trail and you have detailed records and show brand development, you're gonna have some issues. So if y'all want to know about the T is Lady A, very well known Black artist. I didn't know her until this lawsuit happened, but she was very well known by a lot of people. Lady Antebellum is a white rock group. They were called Lady Antebellum for a very long time. Had great music, still have great music, but they got a lot of flack because of Antebellum. So they didn't want to offend people anymore. So they switched to Lady A, so they wouldn't offend anybody anymore. They didn't know that they were stealing somebody else's stage name when they did it. And they filed like 3 trademarks and did it for years. And that person never raised any suit. Then all of a sudden, there was a lawsuit. And now we're in a weird catch-22 where the person who was using it first and the person who filed are now in a predicament where they might not either one of them may not be able to own it exclusively anymore. They might be at that point. That's what happens when you don't take those steps up front. So Lady A might be told, well, I'm sorry, y'all are both going to own it and you're just going to have to deal with that. Or they both might be told, well, neither one of you can own it. It's a true splitting the baby type thing. But the big issue and the biggest critique I have, and this isn't something that I'm like fussing at her about, this happens to a lot of people. Like, what is it that is keeping people from having that conversation and going ahead and trademarking? It's just lack of knowledge. People didn't know. Lady A, we're not being told to go ahead and trademark our stuff. And then when we do trademark it, right, we're going to the legal zooms of the world. We're not looking at the hidden fees behind what happens if you go wrong. We don't ask any questions. We just look for the cheapest thing possible. And because of that, we don't protect all of our rights along the way. We don't actually seek out people who are like experts in the field. Like for me, I seek out a CPA. If Lady A had sought out a trademark lawyer and a copyright or somebody who managed artists as a lawyer very early on, maybe she could have prevented that. But the biggest issue is not filing up front, because now you have to sue, and litigation is expensive. If you win an infringement suit, yes, you could get paid, but you have to win. And if you lose, then you spend all this money to lose. And that's not a good feeling, because trademark infringement law is not something that's cheap. It is a very costly process, and it might take a year, 2, 3 years, dragged out over time before they finally decide who gets what in a case. Michael Jordan had an infringement case last for 8 years with China. That's how bad infringement cases can drag out. So a lot of this can be prevented up front if you go ahead and file first, instead of having to rely on the first use principles and having to prove your geographic regions, your reach, actual sales. All of those things have to be proven in order for you to establish the statutory protections. Because if you file, then you have the statutory protections already in place for you. So yes, people definitely have a dog in the fight. It's called first use for a reason. You were first to use it, but you have to prove first use and prove that they did something in bad faith. And that is the second part that most people cannot prove. You can't prove that they did it in bad faith. You can't prove that they have nothing. And if you haven't developed your brand like you've been supposed to be doing, if you're proving that you're not actually trying to protect it, you're just trying to keep other people from using it, they don't like that either. They want to see a true brand. They want to see a business plan. They want to see that you're moving in the direction of a true product line, and you have deals that you're going to close, or that you're selling products that are going to be sold and people are going to purchase them on a regular basis on a website, on something consistently. And when they don't see that, if somebody wants your stuff, guarantee you there is something called a cancellation of a trademark that somebody can file, and it can get ugly. But yes, if you're not using your trademark, it can be taken.
Okay, so it just really boils down to like the need for knowledge of trademarks and knowing what goes into these scenarios. So, for lack of better wording, you don't get caught up. Got
Yeah.
it. Got it.
Look before you leave. Let's just look before you leave.
Truly. So, after listening to this, is this like a power play, or is it just business?
So I think I'm giving you a lawyer answer, but it depends. It's a power play. It's just business. But I mean, everyone has a price. Glow Kit was the big issue for the court that they mentioned all through the upper court proceeding. And it was all because Dr. Leon assigned all of his rights in his trademark that he got registered to J.Lo. And they were upset with that. I was like, that's not fair. You can't do that. But trademark assignments are valid. Like anything that you write in a contract where both parties understand the terms of the contract, and if you want a big payout for the use of the word Glow Kit, then he can get a big payout. You can't own that. And so because they bought it from a guy that they found out owned the trademark that they wanted, and they were going to put kits together with J.Lo's perfume, and they knew that would probably be a reasonable use of the kit, and they had mentioned this to the office, there's no infringement here unless you are also going to sell glow kits, and you're not. You're going to sell in the beauty industry, but you're not going to sell it the same way. And that's the biggest issue for a lot of people, is that just because J.Lo got it in a contract doesn't mean that she did anything untoward. You just didn't outthink her. Like, that was brilliant. To me, that's brilliant. For me to sit here and put out all of the information I am doing about trademarks and to forget that people can assign their interest in their own trademark to someone else, that's crazy. That you can assign anything that you own, you can assign to someone else. And people just don't recognize that. And so we get caught up in the, my torts professor used to say the F word, the fairness word, but it's not about being fair. It's about business. And if you look at business and how it operates, trademarks need to continue to be used. And if you're not going to use it, or all you were ever going to do is develop this little thing and you wanted to get paid quickly, that's what, I mean, look at patents. Patents have a time limit. You can only get paid off a patent for 20 years. And then everybody they're able to use your patent. So the whole trademark intellectual property industry is made for the public interest consumer to benefit. So it's not made for it to be retained by this one person and them to never give it away. It's meant to continue on. The legacy must continue. And if you're not going to continue Google's legacy, well, someone else will. That's the mindset behind ownership, and especially in the IP field.
Okay, so that makes sense. So really, people just have to take the emotion out of it and just realize that it's business.
I mean, that's what I got to do. I mean, it's not fair, but I got to do that to people. I mean, I got to tell you, look, man, put my stuff down. Don't use that. Don't look. You want me to send you a cease and desist letter, or you want to just stop? Because if you stop, we don't have a problem. But if you want to keep going, then we have to send a cease and desist letter. Same thing with copyright takedowns on Facebook, YouTube, Instagram. Do you want to stop using my stuff, or would you like me to just file a copyright notice and get your stuff taken down? It's a matter of, at some point, you know what you're doing. And if I've told you to stop, you don't stop. It's up to me to enforce it. And it's just like anything else with your life, you have to create a boundary. Business boundaries need to exist. And to get to a point where emotions can't reach you in a certain business boundary. Like, look, this is just my job. If you would like to make this about all the things that are going on, then cool. But at some point, I'm going to have to enforce the issues that I have with you, or you're going to have to perform well. And I think that's where a lot of people get caught up in business. They're like, oh, well, I don't want to look. At some point, you got to just tell somebody explicitly what you're going to do if they don't comply with your request. And if they still don't comply, then you got to carry it out. That's all this is about. Just making sure that you do business correctly. And that's why a lot of people are frustrated with trademarks, is because no one ever taught them how to do this. No one ever taught them how to protect these things. And they were never taught how to invest in themselves this early on. They would never even think to go find Dr. Leon and offer him a deal so they could get the assignments to his trademark. But you can do that. People who own a trademark that you want, you can go ask them to assign that trademark to you. They ain't gonna do it most times, but there are people like Dr. Leon looking for a payday. And if you got the money and wherewithal to pay Dr. Leon off, then you can have a trademark in your name. Okay, I'm not gonna go find the Dr. Leons for you, but I will tell you it is possible. If you find one and you want to get it assigned to you, you can. Absolutely.
Noted. Indeed. So, after doing like a quick Google search, I noticed there were like a couple of phrases that came up, right?
Okay.
So the one that came up was underlying rights.
Mm-hmm.
And then there was another one that came up. It was like what an assignment or a license back agreement is. Mm-hmm. Can you explain what exactly that means in regards to this case?
Yeah. So your underlying rights refer back to common law rights. Remember I told you that you didn't have to get your trademark registered with the USPTO for you to be protected. Those underlying rights are your common law rights. You can protect the symbol, your logo, your product name, all of those things. But it usually comes with a geographic restriction because no one is on notice for all states unless you were doing business in all states and making a decent amount of sales in all of those states. And it doesn't come with those statutory rights of infringement protection that having a filed application does. So that's your underlying rights, is that you are protected through that first use provision, and it's protection under common law at both the state level and the federal level. Some states have their stuff explicitly already stated, and some states have something called, like, you can file a state trademark. Don't do that, y'all. Please don't do that. You don't have to. It's wasted money. I really don't know what it helps you with, because it doesn't necessarily help you in litigation at all. So waste your money on something worth wasting your money on, and federal trademark thing, because you have a federal statutory protective right under there. So I would really look into underlying rights as, okay, I got the common law. Now I need to go obtain the statutory law. Same thing with copyrights, y'all. When you have something copyrighted, you don't have to prove as much if you ever have a dispute. Versus if you don't have it trademarked or you don't have it copyrighted, you have to prove way more to show that you are truly using it. Because you didn't file anything with the USPTO, they have no record of you stating that you have it, and you have not proven to them by their means of acceptability that you're actually using this in commerce. So now you got to prove even more. It's just like court. If you go to court and you ain't got no official filing, got no official certificate, no registration, nothing to say that you went through the process, the haze that is going through the trademark process, then you're going to have to do some more. You're going to show something else to the court to prove what it is. Because there are character references that you want, like a trademark registration, and then there are character references that you don't want. Like, I used it first, Your Honor, here's my Instagram page. Okay, Instagram is not enough. You got to show more. You got to show like a business page. You got to show products that you're selling or services that you're providing. You have to show it on a website. Like, that's what a lot of us do in the trademark industry. And it's kind of hard to communicate that to a client because all most people think you do is what LegalZoom promotes, which is that you just put the information in, we plug it, and we file it. That's not what you're really supposed to be doing. Like, it's a whole process. It's fluid. We do screenshots. We go back and forth. We got to make sure that everything is lined up so your application has its best chance. And you want your application to have a good chance. So that's the main big point on that, is that the underlying rights are about what you have without having filed anything. You have it because you did it. The real rule of copyright law that you can take to the bank every time, whoever creates it owns it. So if you created your logo, as in designed it, then you own it. If you didn't create your logo and you didn't get a contract, then whoever created that logo owns it. Even if you paid for it, if you didn't get it in a contract that says that you will own the exclusive rights, they own it. So understanding underlying rights means that you get it because you created it. If I create my own videos, if I create my own pictures, I am my own photographer, which I am. No, I take great pictures of myself, but I do also get contracts with real photographers and videographers because I want to own my content. Everything that you create, it can be owned, but it's only owned by the person who creates it. So that's your underlying right. The other part, which is what you mentioned, is a license back provision. That is something that the person who has the first right of, like, first refusal, I don't know if you've heard that in contract, like, I get to say no if you pick something and I don't like it. That's what a license back provision is. And if a license back provision says that, and the person who has that right to do that is the person who like assigned over their interest, then that can sort of invalidate the contract, because it's like, wait, but the person who's actually making the decisions is the person who is assigning his interest. So truly, that person is actually truly the owner still. You're just the licensee. That's what that license back provision is. If that's in an assignment agreement, then they're like, I don't really think that's valid, Judge, because the person who has the quality control is the same person who is licensing all of their rights to it. And that's why I always tell people to use the words exclusive copyright rights belong to who? The buyer. Because you shouldn't have any rights after I pay you. And that's the big issue. And that's why they're referring to that license back provision in this case, because it was a license back provision, but it was limited in time and scope to a year. And the quality control was restricted to J.Lo having quality control and right of first refusal, not Dr. Leon, who gave all of his rights in the glow kit to J.Lo.
Okay, that makes sense. I get that.
Mm-hmm.
I just saw a couple of that like legal verbiage, so I just wanted to be able to have it explained, so we could kind of know exactly what's going on. So
It's important. It's important. That stuff is confusing. That's why you got me. That's why you got me. That's why we come here for Trademark That Thursdays. You can just break all that stuff up, make it simple.
So I have one more question for you.
Okay.
So I know earlier you mentioned the Lady Antebellum versus Lady A case. Is there any other precedent that has occurred that has something to do with this particular case?
So there was a couple of cases. One was the Brewski beer case, and they were talking about how things could be distinct and in different areas. So there's a Brewski beer in one state, and then there's one in California, and the one in California serves completely different products, and they were allowed to coexist. This wasn't that case. This is a case about brand building. Who's actually building a brand and has a product line that's really going to launch, and who keeps saying they got all these inquiries, and Nordstrom's supposed to have a national rollout. Nordstrom didn't have a national rollout. Now you can conspiracy theory all you want, but they said that they don't know why Nordstrom didn't nationally roll out the glow kit. I don't know why either, but I mean, J.Lo versus you, one sounds like a better prospect in their market. So I would wait until the one who's going to actually get the major sales is the client as opposed to you, because who are you? J.Lo's not supporting you. J.Lo's not funding your project. So that's just a business decision of Nordstrom's. Like, I'm going to do a national rollout. It better sell because I'm putting it on my stores and buying it in bulk so that it could sell. And J.Lo sells stuff. So that's a smart business decision. But for the most part, they didn't mention a lot of precedent cases besides the one that I really liked, which was Visa. And they were talking about Amberback, and Visa and Amberback had a license back provision that I really wanted to look into, because they were making a big stink about this license back provision and J.Lo's knowledge and all this other stuff and who has control. But in the Visa versus Amberback decision, Visa, who was the licensee or the person who was given the license, was also given quality control of whatever Amberback was able to use. So there wasn't an assignment. Visa always held the interest for that provision because Amberback wasn't given any quality control. In our case, which was J.Lo versus Glow Industries, Dr. Leon actually gave J.Lo quality control rights over everything. So they're like, you're exclusive. You decide what the final, product is that we put out. But J.Lo had that right. Visa retained that right. Dr. Leon did not. And so that's the main big points in this case. They mentioned tons of legal precedent. There were tons of factors in here, but that is too much for y'all's brains today. Okay, I ain't finna go on through this whole process. If y'all want to do that, y'all gonna do an extended cut. We'll have a bonus reel and all that stuff. But there were so many different factors in this test that the high court used. But the biggest one to remember is that they cannot enforce trademark infringement unless they can prove that trademark infringement occurred. And as they stated at the lower level, they have to prove that there was an infringement that occurred. Infringement occurs when there's something worth infringing. As they told them at the lower level, glow, the word glow is a generic term. Trademark infringement suits on those types of terms are very weak and very unlikely to come out positive or in your direction. So if you are going to file a trademark infringement suit, I know you guys are all passionate about your brands, but file one that actually has merit to it, because you created something like a Google or a Xerox or Apple for phones. Okay, you can't file it or you can't use it in a context in which you're not actually providing that actual resource, unlike anybody else. If everybody's using the word glow, all the trademark attorneys like me, which I do this in my office action responses, y'all. All I have to do is cite 50 other companies that are using that same word in this industry, and I prove I'm not infringing, because if I'm infringing, so is everybody else, because they're also using this word. And they wanted to protect the word glow. The word glow, only if it was filed as a trademark and Glow Industries owned it would they have that exclusive right to it and its application. And they mentioned that in the article. You needed to file it. You needed to file and own Glow, the trademark. The only person who owned anything here was Dr. Leon. And Dr. Leon did what he had to do, get his money. Get your money, Dr. Leon, and you get your money. But everybody else, when they're putting together trademark applications, or anybody's putting together a trademark application, the biggest thing for you to remember is that they will always follow that test of strength versus weak trademarks. That's that stuff I told you back in the day. I told you weak to strong trademarks. You hear every trademark attorney you will hear talk about trademarks will always tell you to book your strategy call, because you need to find out if you have a weak or strong trademark. If you have a weak trademark, it's going to be very difficult to enforce later, which means either you rebrand or you listen to some hard stuff about how to enforce this, because it's going to be difficult. Because If you think that you own the words just because you trademarked it, it doesn't work like that. Not in the infringement industry. That's why they call weak to strong trademarks in the actual USPTO. You can look this up. The USPTO, type in strong trademarks. They have a trademarks 101 little packet, and they talk about strong trademarks and weak ones. They will mention it and tell you which ones you cannot really enforce rights against. And generic and descriptive ones, it is very difficult for you to get a successful trademark infringement claim. So do not file on those types of marks. Now, if you own Google, okay, and Google wants to file trademark infringement against you, they just make, see Google listening to my calls, but they just made Google up, okay? They made it up. You can make up a word and then trademark it, and then you won't have so many issues. That's the problem. Most people don't want to do that. They built an entire brand because they didn't consult an attorney first, and then they want me to fix it. And it's fine, I can do it. But I'm telling you, the best way to protect your brand is to get a strong trademark from day one. That way, when you're enforcing it, there's no way they could have stole that from, they could have made it up in their head. They couldn't have been in their kitchen because you made the word up. And ain't nobody used it. There was no prior applications, no prior use. You did your research. That's an easier trademark infringement claim. And if you have to litigate it, you can call their bluff. And they will more likely have to take it down because you made it up. So that's the goal that you want to try to move yourself towards. You want to move out of this mindset that you have to do this on your own and move into a mindset of I need a team. Because teams help you not make big financial costly decisions later that's going to come back and cost you more money. When I have a team to launch my book, which is launching, guys, real soon, but when I have a team to launch my book, I don't have to worry about not making any money. I just have the team launch the book. When I launch my book, I gotta beg all my homies, home girls, everybody, fam, buy my book, please. Buy my book, please. Please. It doesn't work. It doesn't work. Not for me. It stresses me out. So find your team and then stick with those people. Because when you have a team, J.Lo's people were brilliant. They said, you know what? The trademark office mentioned Glow Kit might come into play, and we selling Glow perfume. We gonna find the trademark owner of Glow Kit, and we gonna cut him a contract deal, and we gonna get that trademark. And that's what they did. That's the smart thing that they did. But if you have no team to do that for you, because they didn't even tell the guy who was buying or selling off his interest that he was contracting with J.Lo. They said that the buyer wishes to remain anonymous. And he said, all right, cool, I still want this money. All of it was transferred to J.Lo. That's from having a team that can help you do that, okay? You have to understand when you are doing anything in life, you can't always do it alone. You could, but it'll be exorbitantly more difficult. And that was one thing that I noticed in this entire campaign is that people were having a difficult time. Like, it was very difficult. So, you got a question? Hey, y'all. What's the questions from the viewers out there, Shiny?
So it looks like we got one question. They're asking, what kind of things cannot be trademarked?
Ooh. Yes. Okay, so I want you guys to remember that word, occult. Y'all remember when Cardi B tried to, trademark occult and it like didn't go through? That's because it was a viral term that everybody is using in public. Same thing, even with Taco Tuesday, even though I have said this many times, I really think LeBron could have gone ahead and proceeded through with Taco Tuesday and he was robbed, but whatever. If he ever wants to try it again, I'm here though, here. But either way, Taco Tuesday, those things are viral in public, and a lot of times they will get denied off of that. You also, people don't know this, but that's why I don't worry about my law firm being taken, because you have to get someone's consent to be able to use names in your trademark. So for example, if you tried to trademark Neena Archfield Law Firm, you could try, but you would have to have the consent of the live individual that you are naming in your trademark. And I am not going to consent for you to use my name. You can do whatever you want to do, but you ain't gonna be able to consent for my name. So most people don't worry about their names. Now, that doesn't mean that you're protected on the domain front. So you better go get your name off of the domains, like go buy it from GoDaddy, whatever, because that does not protect you from domain squatters. Okay, they will buy your name up when you become famous, and you have to buy it back from them for thousands of dollars because they bought it right before that you were about to pop off and you were going to hit. So go buy your name. Okay, it doesn't protect you for the domain, just protects you in the trademark industry. The other things that you can't trademark, like you can't trademark a book name. You can only trademark a book series. Book name is for copyright and all of those purposes. You have to have 2 or more books in a series in order for you to trademark the name of that series, i.e. Harry Potter. How many books does Harry Potter have? Many. I don't know. Don't fuss at me. Anyways, like at the end of the day, Junie B. Jones, all of those, they have multiple books in the series. So you can, but you can't do it for books. Like a lot of people come to me like, oh, I want to trademark my book. No, you can trademark your pen name and you can trademark your anonymous pen name. But you got to do it smart, right? Because if you trademark your anonymous pen name and you put the owner of the pen name is an individual, well, you're not anonymous no more, are you, Mark Twain? You can't be, because you done told everybody who owns the trademark, so they know it's you. So your pen name needs to be owned by an LLC. That's what I tell a lot of people. All your trademarks need to be owned by an LLC, and that LLC needs to be an anonymous LLC. Okay, so a lot of people don't think about this stuff, but like books and book launches has been on my mind a lot. So you cannot trademark your book name, only a book series. And then you also can't trademark like vulgar stuff, like cursing and all. You can't be doing that, okay? You can't be putting out vulgar phrases and then like, let me trademark this. Like, it doesn't work like that. Like, you have to be very, very explicit. And you can't, presidents, y'all, are protected. Past, current, and former, okay? They are protected. You cannot go around trademarking the president's name for anything, okay? So they are protected even after they're dead. Their wives actually have rights even after they are dead. Their wives are still alive, they are still protected. So you cannot go around trademarking presidents' names. So if y'all wanted to know some fun facts, don't be trying to trademark your president. Even if you like Joe or Kamala, you can't go trademark her name, okay? You can't do it because first, consent, but then second off, presidents are protected, okay? Just let you know. And I didn't say Kamala was the president. I just spoke into the future, okay? Just telling y'all where it's going to go. In the future, a woman will run for president and win. I don't know who it's going to be, but maybe it's Kamala. I don't know. So those are the things that you can't trademark. We said that for the very end. So if you are watching this video, you got some bonus info about J.Lo and about what you can't trademark. Any other questions from you or the audience, Shane?
That seems to be the primary one that people are interested in. Like I said, I feel like it's just once they start to be able to tap into the resources and knowledge to be able to learn what trademarks are, then most likely that's when the questions would flow.
I think so too. And I appreciate you guys for sticking with us. I mean, like, trademark stuff is very, very overwhelming. Like when you're learning it, especially when I'm learning it, there are a lot of different people out there that are trying to get to know and understand. You know, like Neena have like 85 questions. I was like, call me on Thursday. That's when I'll be available. But either way, like at the end of the day, trademarks, it's an industry that never gets boring because it is constantly changing. Even when I file trademarks myself, I get new office actions that I have never heard of for things that I really don't think should be office actions. I get new ways to file. I found a way to trademark a social media series. Hi, Trademark That Thursdays is registered. But like those are different things that you can do with trademark. But you have to figure out what it is you're trying to put out there. If it's not a brand you're going to put the work in to develop and you just want to own something, then I'm going to tell you, it's not your time. It ain't worth it. Okay. Don't buy my package. Just trying to hold some. Okay. You ain't trying to hold some. This is a 10-year process. Okay. This will take you 10 years before you fully own that trademark with no worries about the USPTO coming back and being like, I don't think you're using it. Cancel. Like USPTO is serious about the continuity of trademark use. If you're going to protect it via trademark, you're going to use it. And if you don't use it, when we do our checkup on you in 5 years and again in 10 years, we're going to cancel this mark if you're not still using it. So that is all what continuity is about. You want to get to that point. Get out of this mindset that you're just trying to protect something, and it's just like filing a name reservation at your, Secretary of State's office. This is a lifetime cement pouring process. And if you're not ready to pour cement on it, or you're going to change your brand, you're going to change your logo, you're going to change your business name, your slogan's not going to stay the same, then don't do it. Do it when you're ready, not just because you want to trademark something that's trending right now. Okay? This got to be you. You got to put all the work in to make this a brand. Because if it don't become a brand, you don't get embarrassed in 5 years when you ain't got nothing to show the USPTO. And they're like, "Where your stuff?" I'm like, "Oh, I ain't done nothing because I was tired after year 3." It don't work that way. So it will go back to the birds, and you won't own it anymore. So you gotta do the work. That's why we here. That's why Trademark That Thursdays comes every Thursday. Y'all thought I was doing this for fun? Just because I liked it? No, it's a brand. It's a company. We're building something. You can't build anything if you don't have anything to build. Okay? You got to have building materials. These are our building materials. We're going to be big one day. I'll be on TV. Speak that into existence. I don't know what TV I'm going to be on. Maybe your TV, because you streamed it from your phone, but it doesn't matter. I'm going to be on TV. So, anything else, Shayna? You want to bow us out? Tell them something wonderful you learned today. Did I teach y'all something? I don't know if I did. Did I?
Nah, for sure. Nah, this is really interesting. Trademarks are interesting. Like, I didn't realize how extensive it was. And then you mentioning like because I low key love Lady Annabella. I'm like, that was so you mentioning that and just giving us like a general idea of like what trademarks are and the complications and challenges that can come with that. Like, priceless. It's priceless.
Yes, Coca-Cola is not a sponsor, but if you would like to make them a sponsor, tell the Coca-Cola person. So I need some money so we can keep doing this. And neither is Starbucks for any of these things. So if you would like to tell them I'm their biggest advocate and their biggest fan, just tell them to check my receipts. Look at my account. I'll be there every day. It's a problem. It's a problem. See? Yeah. I've been rubbed off on my assistant, y'all. I'm sorry. It's a vibe. Like, you don't even have to pay for nothing. You can just go sit there, and it's just a beautiful vibe. Now, you should at least get some water so they don't kick you out because that thing happened. But still, I have never had that experience at my Starbucks. They always treat me with love and respect. I used to bring my lunch from home. Like, look, y'all got some water.
Yeah, we got you. That's a vibe. But the main thing is, as Neena mentioned, we do this every Thursday, and to follow us on Instagram. I dropped the link in the comments. That's where we have a lot of information that goes outside of Thursdays. So that's my main thing. Just check us out on Instagram, and we'll be back next Thursday with another hot topic.
Yes, we will. I don't know what's going to be yet. Don't ask me. If you have suggestions, though, tell Shayna. Neena the last friend at gmail.com. We would really appreciate all that you have to offer. And if you can't remember that, just remember the number that's scrolling at the bottom of the screen and say 205-490-8068. We want to hear this next Trademark That Thursdays. And we'll be happy to get it on the schedule. Get on the schedule. Come on now. We got some cool, fun, quick tips for you guys coming up sometime soon. I have actually kind of batch recorded. I'm sharing with you guys like a lot of content. You can ask my interns people, but I did it like last night before bed. And it's some questions from you guys. So like when you ask me questions, it's not that I don't want to answer. I just want everybody to benefit from the answer. I don't think that you should be the only one who gets an answer to your question. So I tried to save it for Trademark That Thursday so that if anybody had the same question that you did, they can go back and they can find the answer and information. So we talked about the Blue Ivy trademark before. We've talked about Haley Page. We've even talked about WWE SmackDown. And we've even gone all the way over to England to talk about Sussex Royal. So we out here in these streets talking about whatever trademark topics that you can possibly think of. We try to keep it to current events that would really matter to you. But if you want to learn more about trademarks, all you got to do is come. It's free. We do it. It's free. I'm just letting you know. So L.A.S.T@gmail.com. We got you. All you gotta do is say, hey Shayna, I need this. We need to talk about this. Shayna, got you. We will put it on our calendar. We will find a way to really speak into you. Because again, I don't want you to come to me because you're scared. I want you to come to me because you're well informed and you listen to these Trademark That Thursdays and realize that there is something in your brand worth protecting. So much so that you're willing to call, get some done. All right. But y'all know, as always, this is not an advertisement for legal services, and I am not saying that I have greater services than that of other lawyers. I'm just saying this information that you should use. These are peaceful, wonderful nuggets that I have learned along the way, and I hope that you learned something great at this episode. So, bye, y'all.